folks to join before we start. It's 31. Well, good morning, folks. It's nice to see all of you and be back together with you in this important project that started now, well, a few years ago, actually, if we include the first phase of it. My name is Paul Reiber. I'm the Chief Justice, and I'm honored to have this role to chair this project. This is the last meeting. It's a virtual meeting, of course. We're going to go around the table, so to speak, to introduce ourselves in a minute. We have an agenda that's been passed around. The agenda will include, of course, at the end, some discussion and approval of the working group report that the group is required to submit to the legislature next month. We'll take a break about 10:45, 10:50, somewhere in there. As usual, during the presentation that's made by terrific CSG staff, if you have questions or comments, they are very willing to be interrupted. So speak up. If you raise your hand, I'll try to make sure that I see it and interrupt myself, but it's possible I won't see your hand raised. And in that case, just don't hesitate to chime in. Questions, comments are always welcome. This is being live streamed, as our able assistant Sophie had mentioned a few minutes ago, live streamed on the judiciary's website and recorded. So if there are no questions or comments, I'm going to start going around and asking folks to introduce themselves. Sophie, I'm going to start with you. Sophie, will you introduce yourself, please?
Good morning, certainly. Hi, my name is Sophie Conway. I'm the operations assistant. I usually work with Windsor County, and today I'm here with you all.
Thank you. Madeline Dardo. Madeline.
Good morning, folks. Madeline Dardo, Senior Policy Analyst at the Council of State Governments Justice Center.
A. Gunter.
Good morning, I'm Angie Gunter. I'm also with the Council of State Governments Justice Center, Senior Research Associate.
Alice Emmons, Representative Emmons.
State Representative Alice Emmons from Springfield, and I am Chair of the House Corrections and Institutions Committee.
Senator Nitka.
I'm Senator Alice Nitka. I'm on the Senate Judiciary Committee.
Ashley Messier.
Good morning, Ashley Messier, Executive Director, Women's Justice and Freedom Initiative. I'm also a commissioner on the Vermont Commission on Women.
Barbara Morrow. Barbara, you there? You've got to unmute yourself, please. All right. I'll come back. Charity Clark.
Hi, I'm Charity Clark. I'm the Chief of Staff at the Vermont Attorney General's Office.
Dale Crook.
Good morning, Dale Crook from the Vermont Department of Corrections. I am the Director of Field Services.
David DeMoro.
Good morning. My name is David DeMora, and I am a Senior Advisor at the Council of State Governments.
Derek.
Mio Duvnik.
Thank you, Derek.
Good morning. I use he, him pronouns. I'm the Community and Restorative Justice Executive with the Vermont Department of Corrections.
Senator Sears.
Dick Sears, State Senator, Bennington County, Chair of Senate Judiciary Committee. And while I'm at it, I'd like to thank you, Chief, for your leadership over this long period and justice reinvestment too.
Oh, well, thank you very much. I appreciate that. Dr. Nasreddin Longo.
Good morning. Eitan Nasreddin Longo. I'm chair of the Racial Disparities Advisory Panel.
Falco Schilling.
Morning, Falco Schilling. I'm the Advocacy Director for the ACLU of Vermont.
Gary.
Hi, Gary Marvel, Field Operations Manager for the Department of Corrections.
James Pepper.
Good morning, James Pepper. I'm the chair of the Vermont Cannabis Control Board.
Jay Johnson.
Thank you, Chief Justice. And I'd like to second Senator Sears' thanks for all the work you've done chairing this board. Hi, everyone. I'm Jay Pershing Johnson, Governor Scott's legal counsel.
Karen Tronsgaard Scott.
Good morning, everyone. I'm Karen Tronsgaard Scott. I work at the Vermont Network Against Domestic and Sexual Violence, and my role there is as its executive director.
Lisa Ryan.
Good morning, Lisa Ryan, Director of Domestic Violence Response Systems at the Vermont Network. Nice to see you, Mr. Ivory.
You too, Lisa. Loretta Sacchi.
Hi, I'm Loretta Sacchi. I'm a policy analyst with the Council of State Governments Justice Center. Thank you.
Mary Jane Ainsworth.
Good morning, everyone. I am Mary Jane Ainsworth. I'm the Director of the Parole Board.
Matt Valerio.
I'm Matt Valerio, Vermont Defender General.
Monica Weber.
Good morning, everyone. I'm Monica Weber. I'm the Administrative Services Director with the Department of Corrections.
Nick Damel.
Hey, good morning. My name is Nick Demel. I am the Commissioner of the Vermont Department of Corrections.
Pat Gable.
Patricia Gable, State Court Administrator. Good morning, everyone.
Representative Kurt Taylor.
This is Representative Kurt Taylor out of Colchester. I'm a member of the Corrections and Institutions Committee.
Willa Farrell.
Good morning. I'm Willa Farrell. I'm with the Attorney General's Office, Court Diversion and Pretrial Services Director.
Susanna Davis. Thanks, everybody. Anyone I left out? Would you speak up?
I'll just come on and say thank you. This is Barbara Morrow at the Orleans County Restorative Justice Center.
Thank you, Barbara. Anybody else? Any other names I missed? Just speak up, please. Okay. All right. So we'll get going. And again, we have an agenda that's been distributed along with a PowerPoint as usual. The important legislation calls for submitting a final report. This being the final meeting before CSG completes its work on this project, on this particular project. We'll discuss that at the end of the meeting. The meeting is going to close around 12:30, but we will take a break, as I said before. Any questions? Any comments before we start? So I'll turn it over to Madeline. Madeline.
Thank you, Chief. It's really funny. Yeah, it wouldn't be a CSG presentation without a really long PowerPoint. You guys are used to that from us from now on, or by this point. So thank you so much for being here today, folks, as we wrap up our technical assistance. As the Chief said, we've got a couple of goals for today. One is we're going to do a little bit of a deeper dive into the implementation, particularly of Act 148. The Department of Corrections and the Parole Board have been working really hard over the past several months to pull some additional data and set up data practices, so data collection practices, and be able to report out that information. So we've got a lot more data to show you all today to talk about how things have been going, but also things that you need to be looking at moving forward in order to continue to monitor Justice Reinvestment 2. And then the other piece of the presentation today is really going to be focused on that report, as the Chief said. So if you all remember, you have your second report to the legislature due in January, and that's going to include your recommendations around parole for older adults, reinvestment appropriations that we talked about in October. It seems like forever ago, but it really wasn't that long ago. And so we'll revisit those recommendation decisions that you made in October, as well as the recommendations from November around the racial equity and sentencing analysis. So you'll see those slides are going to be really wordy, partly because we want to make sure that we're double checking that wording with you all, and that everyone feels comfortable with how those recommendations are phrased, so that can become part of your report to the legislature in January. So we'll talk about that a little bit as we go through the presentation today. But then, as the Chief said, when we get to the end, we'll be able to have kind of more of a discussion about what that report looks like and what you all are comfortable with moving forward. So I'm going to go ahead and share my screen. All right, can everyone see that?
Yep.
Great, thank you. You'll be hearing a lot from me this morning, but also I'll be joined by my colleagues, David Demora and Loretta Sacchi, so you won't just have to listen to me drone on and on for the next several hours. As you all know by now, we are the Council of State Governments Justice Center. We're a national nonprofit, nonpartisan organization. And we've been here in Vermont for about 2.5 years now in support of the Justice Reinvestment Initiative, which is funded through the Bureau of Justice Assistance. And so to give you just a little bit of a national context about the Justice Reinvestment Initiative that you all are a part of, there's actually been 40 states that have used the JRI process to address correction spending and then reinvest that money in strategies to increase public safety. 33 of those are states that we've provided assistance to. And the results of that assistance, we think, is pretty impressive here on the left, and the work that those states have done in an estimated cost savings or cost averted of about $3.2 billion, being able to reinvest about $650 million back into community-based resources, and then thinking averting prison population growth by over 82,000 people, and reducing prison populations in total by more than 24,000 people, which has been able to result in about 21 correctional facility closures. So just putting in perspective that the work that you all are doing is part of kind of a broader national movement. And there are several different ways that folks have approached justice reinvestment. As you all know, it's tailored to the specific needs and challenges of the state. And most commonly, though, we do see people addressing behavioral health challenges, recidivism reduction efforts, being able to address gaps in data collection and analysis capacity. And then also just overall, we're looking at ways to manage correctional costs and spending. So we've got 4 parts to our presentation today. We'll be taking that break kind of right after that the criminal justice trends section. The first section, we're just going to do a quick overview for you all about Justice Reinvestment 2, how we got here today. We know there are some new faces, so hopefully this will be helpful in setting up the conversation moving forward. But we also just like to leave you all with a document that you can use for reference after we're out of the state. So that'll just be an overview of a lot of what you all already know, but we'll move pretty quickly through that this morning. And then we'll go into a little bit more of that data that I was talking to you all about. We've been able to show you over the past several months those snapshot population trends for the corrections population as well, or the community supervision population, as well as the sentenced incarcerated population. And we've actually got a significantly more amount of data, again, thanks to the Department of Corrections and the Parole Board, to be able to dive a little bit deeper into what's potentially behind those snapshot population trends, to the implementation of Act 148, as well as your working group recommendations from last year. And this will also be where we'll be talking about those 2022 recommendations. And then finally, we'll wrap up with just some recommendations around how you can continue to sustain your Justice Reinvestment 2 efforts, and then what to expect from us as we close out our technical assistance. All right, so as many of you remember, we started this effort with you all in June of 2019 when Vermont leadership requested technical assistance for Justice Reinvestment 2. It's Justice Reinvestment 2 because you all had already used a Justice Reinvestment approach in 2007 to address increases in your incarcerated population. And so as a result, this working group was formed, and there were several different areas that were identified for you all to dive in and look at potential policy recommendations. And so we've got a couple of those listed here. So looking at how increases in some categories of crime may be impacting parts of the criminal justice system, looking at that connection between supervision revocations and incarceration, better understanding behavioral health challenges in the state, and then also looking at, again, how ways to improve data tracking and analysis capacity. And so from August 2019 through to January 2020, this group met 5 times to examine the results of CSG Justice Center's data and analysis and stakeholder engagement, and to be able to develop the policy recommendations that eventually became Act 148. And so, as I mentioned, this process was really informed by significant stakeholder engagement. You can see here all the different people that our previous CSG Justice Center Phase 1 team engaged with, folks that are engaged on the front end of the system, also with incarcerated populations, as well as the behavioral health system. And then our team was also able to do a data analysis, looking at several different sources of criminal justice information here, and to really be able to think about identifying those drivers of incarceration in the state. And this might look very familiar to some of you. One of the main findings of this particular analysis was that about 80% of sentenced DOC admissions were people that were returning or revoked from community supervision. So you'll see here those new court commitments made in the orange made up about 20%, and then folks returning based on parole violations, probation violations, or furlough violations was that almost 80%, with 53% being furlough violations. And also, as part of this data analysis, you all reviewed information around the increase in the sentenced incarcerated population and the impact that that might have on, particularly on out-of-state contract beds. So what you see here, and again, noting that this is all kind of pre-COVID, pre-Justice Reinvestment, there was a projection that, should those, the kind of status quo increase continue in the sentenced incarcerated population, that you all would also see a similar increase in out-of-state contract beds that could eventually cost Vermont about up to $43 million by the end of fiscal year 2025 in those contract beds. And so to address these challenges and then other public safety challenges, including those related to behavioral health, the working group you all got together, developed a package of policy reforms, and these are kind of the 4 goals that those policy reforms aim to address. So that's reducing recidivism and revocations to prison, achieving a more equitable system across gender, race, and geography, and then also improving data and reporting to inform decision-making, and reinvesting in policy implementation and sustained progress. And so those recommendations became the foundation of Act 148, which was enacted in July 2020. And just want to make a note that is in the midst of a global pandemic, that you all really continue to persevere through some very tough times to move your justice reinvestment legislation forward. We'll talk a little bit more when we get to the policy specific section about these particular, about each of the policy reforms that were in Act 148, but you'll see them all listed here. And then in addition to the policy reforms in Act 148, the legislation also reconvened this working group and then tasked you all with some additional policy recommendation. And you all ended up doing 2 additional rounds of policy development, looking at some of the bullet points that are listed here. And again, we'll go into those a little bit further, but if you all remember, you looked at earned time for probation as well as midpoint changes to the midpoint review process, several different ways of examining challenges to behavioral health, information sharing, and care coordination. You all also looked at parole eligibility for older adults, and then reinvestment funding recommendations. You were tasked with studying presumptive probation, but declined to study that at this particular period. And then, so after the passage of Act 148, again, Vermont leaders came together and requested continued technical assistance from the Justice Center, this time focused on the implementation of those Justice Reinvestment 2 policy changes. And as a result, from February 2020 through December 2021, this reconstituted working group met 9 times to monitor implementation and also to do that additional policy recommendation work. I just want to take a minute to this is a pretty crowded slide. And part of the reason it's crowded is because you all have done a lot of work. And I think this really shows a sustained commitment to you all, to justice reinvestment efforts in your state, and you all coming together to continue to support them during not only, obviously challenges due to the pandemic, but also on top of your, the everyday stresses of the work that you already do. So this is a significant amount of time and dedication, and we really appreciate that from this group. And so as part of our support, you'll see here just a couple of the ways that we've been able to assist you all in the work that you've done. We've been able to provide expert guidance, including focused on the implementation of Act 148 and evidence-based practices in community supervision. I'm continuing to support the Justice Reinvestment 2 working group, as we're doing today, developing outcome measures and ways to be able to establish data measures and tracking processes with the Parole Board and the Department of Corrections so that you all can really monitor the impacts of the policy reforms that were in Act 148. I'm supporting collaboration among all of the many different departments and agencies that touch the corrections population, including the Department of Corrections, the Parole Board, and the Agency of Human Services. And then we've also been able to provide grant oversight for the $430,000 in subaward funding that you all received for participating in the Justice Reinvestment Initiative through the Bureau of Justice Assistance. And so you'll see here at the bottom, we kind of like to show you all that our technical assistance includes 23 working group meetings and presentations, 345 phone and video calls, which may be 378 interactions with you all too many, but we do appreciate the times that you all have picked up the phone, have scheduled that meeting with us. We could not do the work that we do without these 378 interactions. So thank you. And then finally in this section, I just mentioned that Vermont received a subaward grant from the Bureau of Justice Assistance for $430,000. And so you'll see here, this is what you all are currently in the process of using this funding to support. And it includes, I want to note that it includes a significant amount of training that the Department of Corrections, the Parole Board, and the Agency of Human Services is in the middle of implementing right now. This includes training for Parole Board members, supervision officers, and community providers on using risk assessments to better target interventions. It also includes a cross-department organizational level training on collaboration and implementation within the Agency of Human Services, training on evidence-based housing practices for providers that received funding through DOC's RFP process for transitional housing, and training for supervision officers on evidence-based correctional practices, and then more training for supervision officers and community providers on how to support people in community supervision that have complex mental health and substance use needs. And then there are investments being made in improving DOC's data system to improve data collection and analysis capacity. We'll be talking about those particular improvements a little bit later in the presentation. So that was kind of a quick and dirty how we got here. Does anyone have any questions before I move on into the criminal justice trends section and we start talking a little bit more about Vermont specific data? All right. So one thing I want to mention before we go into the criminal justice trends section, the majority of the data that you're about to see is collected through the data monitoring process, which is a requirement from the Bureau of Justice Assistance of states that receive technical assistance from us through the Justice Reinvestment Initiative. So Vermont is required to collect and report to us data related to Justice Reinvestment 2 implementation while we're in the state and then up to 2 years after we leave. So this might sound familiar to you all. We've talked to you about this before. And so this has really been the work that we've been doing with the Department of Corrections and the Parole Board to set up these outcome measures and begin that data monitoring process. And so when part of what this does is it allows us when we leave the state to continue to kind of monitor implementation, because implementation is a long-term process for you all to be able to fully realize the impacts of your policy reforms. The other part of this is that once we leave the state, we will be able, as we receive this information, we will actually be reporting it back to you through a series of data monitoring reports over the next 2 years. And so a lot of what you're about to see, isn't just going to be a one-time thing, right? Like these are going to be measures that we really recommend that you all continue to track moving forward. And we hope that these data monitoring reports that you'll begin to get in about early next year will help you be able to do that. So you'll continue to see those from us during the duration of the 2 years that you're reporting data to us. And so moving into the criminal justice trend section, we obviously want to make the caveat, and we've talked about this with you all several times, that COVID-19 has made a significant impact on trend data, and it makes it really challenging in Vermont, and then also, obviously across the country to monitor the impacts of policy reforms. And so obviously, and we'll show you this again in a minute, but Vermont's sentenced incarceration population has really fallen significantly below what our original Justice Reinvestment 2 projections were. And again, this is largely due to the impact of COVID-19. And so we do think, and one thing we're really excited about is that DOC has started tracking and reporting admissions data. There's going to be other information that's going to be available to you all down the road through those data system updates that will allow you to be able to kind of get underneath those trend lines and be able to understand a little bit better, the impact of your criminal justice system reforms. So that's what we hope to kind of show you today is those points that, even though it's going to be a while before you're able to have trend lines that aren't heavily impacted by COVID, there are going to be certain measures, and we're particularly looking at those returns to incarceration that are going to be helpful for you all moving forward to be able to do the best that you can to monitor the impacts of Justice Reinvestment 2. And so you all have seen this chart several times now. So this is the projections for your sentenced incarcerated population. You'll see that dotted line is the status quo projection that was done by our phase 1 team initially. This doesn't take into account, obviously, COVID or the impacts of your Justice Reinvestment 2 reforms. And then below that, here in the orange, these were our original phase 1 team's projections. So this is the reductions based upon the reforms that you made as part of Justice Reinvestment 2. And then obviously you see here in the dark blue line, this is your actual population as of the end of October, and that significant decrease again due to COVID. And then you'll see a little bit of a leveling off, or it's really kind of just like a barely slow uptick. There's been about an increase of 24 people since April of 2021. So you're not seeing, there were some concerns, about that kind of rapid rebound for the sentenced incarcerated population as things started opening back up. That's not something that we see in the data as of yet. And so, as I mentioned, that significant drop in the sentenced incarcerated population that really drove the total population decline was due to a historically low admissions. And you'll see that here. There's an estimate of 2,654 admissions for fiscal year 2021, significantly lower than previous years, rather than it being the result of releases. And this is pretty common. This is what we see and several other states that we work with. That it's really admissions that has driven these, a reduced admissions that has driven these drops in corrections populations. And so when you look at these reductions in the sentenced incarcerated population across offense types and by race, what we saw is they're fairly consistent. So on the left here, you see a % change in the sentenced incarceration population by offense type. And you'll see that there is a slightly more of a reduction for those felony non-person offenses, so property, drug, motor vehicle here, than there are for felony person or serious offenses and the misdemeanors. But overall, fairly consistent drops in across all offense types during the kind of COVID timeframe of March 2020 through to September 2021. And then when you look across by race, you see something very similar as well, that there was that % change was fairly consistent across racial groups. And so this is going to be a really interesting slide, we think, for you all to take a look at. So as I mentioned before, DOC is now tracking admissions data, is able to report on that. However, we only do have about 4 months of data represented here. So I do want to caveat the fact that this is not enough data to be able to say a trend or to make any kind of hard judgment calls on what you see. However, one thing that's really important to note here is that when you look at who is being admitted from the sentenced population from this July to October period of 2021, what we're seeing is the vast majority of these admissions are not furlough returns, as we saw in the previous kind of pre-Act 148 data that I showed in the introduction. But they're actually coming from probation returns here. So rather than having 53% of those returns being folks coming back from furlough, only about 9% during this time period were folks returning from furlough. And so that's really good news for you all. Like I said, there's no, this is a very limited time frame. We know that this is also still a very strange time in the justice system. But this is an indication that, you know, there's things are heading roughly in a good direction around reducing those furlough returns. And so part of this could be, and if you all remember, part of Act 148 was to stop that kind of churn of those short-term sanctions. And so when you, so there are not many of those people coming in and out of the system at the rate that they were before. We do, you know, it is interesting, you know, that there is the vast majority of these returns are now from probation. Some of that could be that the numbers basically, because the numbers have adjusted, those proportions have adjusted. So not necessarily that there's that vast uptick in probation returns. It's just that there's lower returns coming from other places or new sentences. And then just generally thinking about those disruptions in the court system, it'd be interesting to know a little bit more about how that's impacting the 63% here. But in general, we think this is going to be a really important place for you all to continue to focus moving forward. And so as you start to get more data to really be able to establish those trend lines, thinking about, you know, how are people, you know, what does that look like with folks kind of returning from probation, returning from furlough, and how is that impacting the changes that you're seeing in your overall sentenced incarcerated population? And so, as I mentioned previously, there was, you know, that significant increase in the sentenced incarcerated population. We also took a look at the detainee population here, and you can see that there is starting to be a slight uptick, about 9% in the detainee population, and just thinking that this could be reflective of an increase in court and law enforcement activity as things begin to open up. Even though we're not post-COVID, I can't say that during COVID. And so, of course, you know, as we talked about before, when we were originally doing projections for you all as part of the Justice Reinvestment Phase 1 process, you know, we talked a lot about kind of that increase in the sentenced incarcerated population would also mean an increase in your out-of-state bed usage. So the reverse has been true, as you all have actually, you know, significantly decreased your sentenced incarcerated and your total incarcerated population by about 20%. There's been a 41% decline in folks that are housed out of state. So in March of 2020, there were 246 people housed out of state. And now that number is down by the end of October is down to 145. This is also a chart that should be fairly familiar to all by now. This is the community supervision population. You'll see again that dotted line here is the projected kind of status quo of what would happen. Does not take into account Justice Reinvestment 2 or COVID-19 impacts. And then you'll see in the blue solid line, you see the drop that we've talked about before due to COVID in the community supervision population. And there continues to be kind of a decline here with about 840 people less since March of 2021. So continuing to see that decline in the community supervision population. And so to go a little bit deeper into this, we were able to actually look at this now by caseload populations. And so what you'll see here, I think is particularly interesting, is that basically there's a decline across all caseload population types. However, there's been a really significant decline in the furlough population, about a 31% decline. And so while we haven't necessarily seen kind of an uptick in the parole population, so people instead of being on furlough, that they're on parole, that's not wholly surprising, basically just given the fact that there's a decline in all populations at this point. However, we do think this is a really interesting finding and something that you all can kind of continue to track moving forward to understand if Vermont really is moving away from that reliance on furlough that was one of the primary goals of Justice Reinvestment 2. And so another thing we were able to look at, and again, this is just data from July to October of 2021, so this is a really short time period, but is community supervision completions compared to community supervision placements, with the idea being, if you're thinking about managing your community supervision population, wanting and being able to target resources that we know are not unlimited to folks that need them the most, you want to try to make sure that ideally you want those folks you want to have your completions exceed your placements. And so what we'd see here, just again for these 4 months, is that that's pretty much the case, that placements our completions are exceeding placements for community supervision in Vermont, with the exception of work crew, just a small number down here. And so what we really think about when we see this is, in particular, as you all are thinking about the changes to your midpoint review process and being able to discharge people from supervision who have been successful, and that could be something that really helps you be able to keep that placement to completion ratio to where you're not seeing a significant rebound in your probation population. And we'll talk a little bit later on about the midpoint review process and expanding that back to include the fully currently supervised population, so that you can really maximize the impacts of that particular policy reform. And so the last slide in this particular section is related to the collection of Hispanic ethnicity data. So DOC in 2020 adopted what is a best practice for the collection of race and ethnicity data, which is to collect Hispanic ethnicity separate from race. And so what this did is actually revealed a previously unidentified demographic within the corrections population, but also potential or also disproportionality. And so what you'll see here is that, if you look at the very bottom here in the right-hand corner, is that so Vermont's census Hispanic population for 2020 was 2.4%. When you look here at the total incarcerated population by race and ethnicity, ethnicities here on the right in the kind of darkish blue and the green, you'll see that 11% of the total incarcerated population identify as Hispanic. And then same thing over here, if you look at the community supervision population by race and ethnicity, you'll see 7% of the community supervision population identify as Hispanic. And so this is obviously significantly more than that 2.4% here, which is the Vermont total Hispanic population. And so for those of you that were with us in November, and we talked about how for the racial equity and sentencing analysis that we were unable to do the analysis for the Hispanic population that we could do for the Black population, because we just didn't have those sample size numbers, but we anticipated, or we kind of thought that there was some undercounting going on due to the data collection practices. This kind of reinforces that you know, if there was consistent data collection across points in the justice system, including for law enforcement and the courts, for Hispanic ethnicity data, it's very highly likely that you all would have those numbers to be able to do the level of analysis that we did for Black-white disparities for Hispanic-white disparities. And there's and this is kind of initial findings that showed that there is a need to look at that there is disproportionality, and there's a need to dive into this further. So before we get into the policy, well, we're way early for our break. Do folks have any questions?
Madeline, do you want to take a break now? Is that it, or how do you want to proceed?
We can leave it at, we're happy to keep going. If folks feel like, I mean, we haven't even been meeting for an hour now. So
Yeah.
To adjust if that works for the group.
I think it does.
All
I'd say
right.
so. Yeah.
We'll keep going then.
All right.
Like I said, you all please feel free to stop me as we're going if you have any questions. So the next section of the presentation, we are focused on policy-specific implementation, so that we'll have a little bit more, we're going to dive in a little bit deeper around Act 148, particularly presumptive parole, earn time, and then the changes to community supervision and the furlough system. But we're also going to go over your 2021 working group recommendations, and then obviously we're going to talk a little bit more about your 2022 recommendations and some of the language for your report. So I want to just take a moment and for you all to recognize that this slide really represents 3 rounds of significant policy development by this group. This is not necessarily, it's becoming a little bit more the average for our justice reinvestment states, but I still think that you all have done probably some of the most extensive kind of ongoing policy development that we've seen in a justice reinvestment state. So really kudos to you for continuing to commit to using a data-driven process to making reforms in your system. So focusing first on Act 148 and the adoption of presumptive parole. So you'll see here several implementation milestones from the adoption of presumptive parole. You know, DOC and the Parole Board collaborated, did a significant amount of effort to co-implement new parole processes and policies by that January 1st, 2021 start date. The Parole Board really stepped in and began tracking some of the presumptive parole data that was necessary to understand implementation, and we'll go through some of that in just a minute. Pending the, while DOC was working on changes to their data system to be able to track that through their data system. And then the Parole Board also during this time adopted the Ohio Risk Assessment System, the ORAS, some of you might have heard it referred to, which is a tool that evaluates risk and need. And so this is the tool that DOC uses. And the Parole Board was able to shift away from a previous tool to this more evidence-based method of evaluating risk and need that also really aligns with what the Department of Corrections was already doing. And you'll see here, there's a couple of pieces that are still in progress. One are those data system changes to support presumptive parole data collection. And then also, as you all know, presumptive parole eligibility will expand to include some listed offenses as of January 1, 2023. And so, as I mentioned, the presumptive parole became effective January 1, 2021. And since then, there have been 14 cases that have been referred to the Parole Board for presumptive parole consideration. And then you'll see here in the chart on the left that of these 14 cases, 9 were approved through the presumptive parole process. 5 of them were actually scheduled for a hearing. And so the parole board has can schedule a hearing for a presumptive parole case if there's a victim of record that would like the opportunity to engage. And so 5 of these were scheduled to provide opportunity for that victim input. Of these 5 cases that were scheduled for a hearing, none of them were actually denied based on that victim input. There's been 1 denial, and that was for reasons that came up in the hearing independent of victim concerns. So we do want to highlight that this is about 60% fewer presumptive parole cases than we had initially projected as part of the phase 1 policy development process. 60% does sound like a lot, but we're really talking about kind of 33-ish cases is what we had projected this would be. You all have ended up with about 14. And so we do think that there's a couple of reasons, and we're going to talk a little bit more about this, about why there's a lower number. Obviously, we understand that there's been COVID impacts to the system, but we do think there's a couple of other things that you all can kind of look at moving forward as you're thinking about monitoring the number of referrals that are getting to the parole board for presumptive parole to be able to maximize outcomes for this particular policy. And so one of these things that we think it's important to look at moving forward are the statutory reasons why a person who is convicted of an unlisted offense may not be referred for presumptive parole. And you see a list of those here. And these are all from Act 148. So a person can't have a new criminal conviction. They can't have an outstanding warrant, detainer, commitment, or pending charge. They have to be compliant with required services and programming and their supervision conditions, if applicable. There can't be a major disciplinary rule violation or a pending infraction or a prior parole revocation. And the Department of Corrections is also able to make a determination that a person cannot be released safely or that they're not willing or capable of being a law-abiding citizen. And so we'll see here on the left, on the chart on the left, that the parole board during this time period, so from January to November, did see about 82 non-listed cases for initial eligibility hearings outside of that presumptive parole process. So for whatever reason, these 82 people were not eligible for presumptive parole. And so one of the things that that DOC will be able to understand a little bit better through their data system changes are which of these particular reasons are keeping people from being eligible for presumptive parole, which is going to be kind of a key understanding for you all to know if there's any tweaks or any adjustments that you want to make to be able to get those referrals, to be able to maximize the number of referrals for presumptive parole that makes sense to you all. But this is a relatively larger number of non-listed folks that are receiving initial eligibility hearings and not presumptive parole than what we had originally anticipated. So you might also remember as well that Act 148 also changed the time frame for when these initial hearings would occur. And so they are now required, the initial hearing must be completed at least 30 days prior to a person's eligibility date. And you will see here that, again, from that January to November 2021 time period, only about 27% of these hearings were completed within this time frame. About 62 were completed shortly after, so within the following 3 months. And so about 30% of the people that receiving eligibility hearings during this time period were already released onto furlough. So we're showing this, and we think it's important basically because one of the primary goals of Justice Reinvestment 2 was to move away from reliance on furlough. And so what you don't want to have happen is that folks are released onto furlough and then kind of move through the parole process. You want to prioritize that the parole process and presumptive parole when possible to reduce that reliance on furlough. Another concern that's also come up with folks being released onto furlough prior to parole consideration is that there's a potential that we're seeing lower numbers of presumptive parole cases because folks are waiving parole consideration in favor of continuing to earn time on furlough. And so we'll talk about that a little bit more in a minute. We don't have any kind of initial data on this, although we know it's something that the Department of Corrections and the Parole Board are looking into to understand a little bit more about how that's actually operating. But what we are hearing that there is the potential that there is some underutilization of presumptive parole because folks are opting to earn time through furlough. And so those changes to DOC's data system that are funded through the sub-award that I talked about previously will provide you all with some additional information other than what we just showed. So you'll have a better understanding of the total number of people who've reached their minimum, of those total number of people who's eligible, and if they're not eligible, what's the reason for that ineligibility? Which of those statutory reasons does apply that's meant that person is not referred for presumptive parole. And so moving forward, based on the information that we just went over, we do have just a couple of things that we think you all should are going to be useful for you to pay attention to. And as I mentioned, one of those is continuing to monitor the volume of presumptive parole referrals and approvals. So why are people who have served their minimum sentence deemed ineligible? Are there extensive ineligibility based upon specific statutory exclusions? And is there a place to make adjustments there? Are people refusing presumptive parole to remain on furlough and receive earned time? Looking into that a little bit more. And then if people are being denied presumptive parole, if that hearing is being set, what's the reason? And if they're being denied after that initial hearing, what's happening there as well? If you start to see a little bit more of a decrease in the grant rate. And so we also recommend that the Parole Board continue to focus on moving away from that reliance on furlough by supporting the presumption of parole without a hearing, unless there's that victim of record who can be contacted and would like to provide input. And I think, I know that Mary Jane Ainsworth and the Parole Board have been working on ways to just make sure that there's not that particularly headed into some listed offenses being included in this, where there's going to be more of a likelihood that there will be a victim of record, that there's some upfront work kind of done to be able to understand if that victim of record can be contacted, if they would like to provide input in a hearing, and therefore it's necessary to move forward with that hearing rather than just kind of that automatic scheduling, which could potentially just kind of negate the presumptive piece of presumptive parole. So it's really just taking that due diligence, moving it up just a little bit, and making sure that all of the necessary steps are made prior to a hearing being scheduled. And then finally, we do think that if moving forward, if there are a significant number of people that you all are continuing to see or refusing presumptive parole to remain on furlough and receive earned time, it could be time for a consideration of either expanding earned time to people on parole or finding ways to really encourage the Parole Board's existing early discharge mechanisms that they already have to really just avoid creating that incentive for people to stay on furlough.
This is Representative Emmons. I have a question that pertains to Parole Board should continue to move away from the reliance on furlough. And connecting this with the statutory requirements of what constitutes presumptive parole. And I'm wondering if it's not just the Parole Board needing to move away from the reliance on furlough, but the DOC needs to move away from the reliance on furlough as well and move more towards presumptive parole. Because one of the statutory requirements, I don't have it in front of me right now, but it would be DOC determines that the person cannot be released safely. And maybe DOC feels that the person could be released on furlough more than presumptive parole. So I'm wondering if it's coming from both ends.
Mm-hmm. I think that's a really good question, Representative Emmons. And I think that's one reason why we really just encourage you all, and we're excited about the potential to be able to actually track those ineligibilities based upon these statutory reasons, including having that understanding of, is it is it new criminal conviction? Is it, is it non-compliance, right? Like what is it that DOC determination? Like what are the kind of driving reasons? Will give you a better understanding of that.
Madeline, I can comment on that.
Sure.
So our current policy now with Justice Reinvestment is anyone that we would recommend for release on furlough, we are making a positive recommendation for parole. So everyone that is released on furlough would have a positive recommendation for parole. So just to help kind of understand that framework.
Thanks, Dale. All right. So I'm going to actually toss it over to my colleague, David Zamora, to talk a little bit about the changes to the furlough system and community supervision.
Thanks, Madeline, and good morning, everybody, again. One of the things that Act 148 did was streamline the furlough system, and it established a review process for furlough revocations. And DOC went full bore on this in terms of implementing it, and in fact, including some additional community supervision reforms that weren't required in Act 148. And so some of the things that have occurred has been a revision of the furlough statuses and the creation of a revocation review process. Ceasing furlough interrupts less than 90 days, creating a new threshold for furlough interrupts greater than 90 days, and to begin tracking the returns to incarceration, including furlough returns. In addition, a revision of community supervision conditions and contact standards to better align with evidence-based practice. And DOC and the Parole Board actually both worked on these. They did some tremendous work on this, and I really want to call that out in terms of the work that was done. In addition, they also revised the sanction grid to establish response tiers that are aligned with evidence-based practices and supervision. Very often what happens is that when sanctions grids exist, they're sort of a one-size-fits-all set of sanctions, which does not actually make much sense when we're dealing with people with different levels of risk and with different kinds of ways that responses will work with them. Certain responses will work better with some folks than with others. As you've heard and we'll hear again, the DOC is still in the process of making data system changes. It's a very complex thing to do, but they are working on that, and because there is a great need to be able to collect incentive and sanction data. And one of the reasons why that's important is that we know that the use of incentives is as important, in fact, more important than the use of sanctions in terms of getting folks to be successful. Roughly a 4-to-1 ratio, if you will. It should be 4 positive, 4 incentives, if you will, when we talk about that. And by incentives, by the way, that can be nothing more than praise. Sometimes when people hear the word incentive, they think, oh, we're giving some kind of a big reward to people that they don't deserve. Incentives can be praise, can be emotional support, and it can be things like a bus card or those kinds of things. But understand that incentives are simply responses to when people do the right thing. And that's what it's about, rather than just respond when somebody does the wrong thing, just like when we raise our families, we want to respond when people do the right thing. Next slide, please. One of the nice pieces of information in terms of all of the things that DOC has been doing around this is that the preliminary data from 2022 actually suggests that the furlough returns are on track to be significantly lower than prior fiscal years. And again, some of that no doubt is related to the issue of COVID, but it is also clearly related to the thinking on the part of DOC about how to redefine what furlough is, to think more about how furlough officers should be more in line in terms of their thinking and their work as our probation or supervision officers. And what you see is from July 2021 to October 2021, an estimated 22 people per month were admitted to custody on a furlough supervision interrupt. If that volume remains consistent, then returns will be far lower in FY 2022 than in prior fiscal years. And another important piece about this is on the next slide, if you wouldn't mind, Madeline, which is that when we look at this snapshot population, 205 folks were incarcerated for a furlough interrupt, with 82% for a year or more. That trends in the right direction. When you're going to interrupt people's time in the community, potentially creating problems for housing, potentially causing loss of employment, when you're doing that, you want to do that for people that are presenting with a public safety risk. You want to do that for folks that really the least of the worst options is to incarcerate them, if you will. It's what you have. When you have a lot of short-term interrupts, that suggests that that's not the way you're looking at it. When what you have are interrupts like this that are in fact a year or more, then it suggests that there's a very significant issue that is occurring and that has a clear relationship to community safety. Now, we can't yet determine that exactly because the data system is still being developed, but as those updates occur, we will be able to have a much more nuanced understanding of the population that is incarcerated for interrupts. Next slide, please.
Before you go, can I make a comment or ask a question? Dick Sears.
Of course, Senator.
David, I think of all the statuses that create more community angst, it's the furlough system. And usually these people going back for a year or more, which I understand what you just said, and it's helpful. But these folks often have been huge problems in their communities. And so it gives the entire furlough program a bad name, whereas when sometimes somebody's interrupted for 36 hours, it's a way to control the behavior or whatever. I'm just concerned that who are we letting out that needs a year? Are we re-examining why those people were failed and whether or not the decision to furlough was a good one or bad one? I mean, I think it bears more watching. I think these are great statistics, but it does create community problems. I think I hear more about the failure of the furlough system than any other criticism of corrections from my constituents.
Mm-hmm. Well, actually, the next slide will perhaps help answer some of those questions, Senator. The current answer is that.
I'm sorry. I tried to raise my hand, but I guess I have to interrupt.
Go ahead,
Valerio. As we know, the law changed relatively recently to give some due process rights to individuals who are getting interrupts greater than 90 days. And the Prisoners' Rights Office has relayed to me that what they are seeing is interrupts greater than 90 days that would never have been greater than 90 days. And this is for technical violations, greater than 90 days than that in their view, would not have received interrupts greater than 90 days. So they're going to court on these, and the early results, and it's very early because it's very difficult to get anything in and through the courts nowadays, is that a lot of these decisions are being overturned by the court, and the furlough is and the interrupt is being terminated. So, I don't know exactly what's going on. There's some suggestion that the department is imposing greater than 90 or lengthy interrupts than they would have for similar behavior in the past. I don't know if that's the case, but in getting them through court, so far it seems that a good number of them have been reversed. And maybe this is just the early working out of the kinks and how this process is going to take place, because it is relatively early. But Prisoners' Rights Office is getting a lot more of these than they thought they would, and they're all for technical violations. They're not for new crimes or the like. So I guess they're, if Senator Sears' constituents are not happy with the way the furlough is being implemented, neither are the clients who are subject to it. So to me, there's still work to be done in that area.
Which I think does lead back to these comments here in terms of data, because what you're both describing are the opinions of folks. And so we don't know the numbers. We don't know how many of those more than 90 days are the 180 versus the more than a year, which would, that would be a significant issue as well. And we don't know how many of the interrupts are technical violations, which can be a significant violation or not, or if it's new crime. And so one of the things that the data system will provide in terms of really looking at this issue and tweaking it, if you will, over time, is looking at the total new furlough interrupts each month, looking at the reason for furlough interrupts, as I said, significant violation or new crime, and then the length of the new interrupts, to get back to Matt, what you were saying in terms of, how long are these for? And you could add a fourth bullet here, I think, perhaps, which is how many are overturned, if you will, when it's brought to court. So there is additional information to get. This is the beginning early on. I see, Dale, that you have turned your camera on. Did you want to make a comment?
Yes, sir. I mean, the department would like to kind of disagree with some of that assessment from Mr. Valerio. The returns that are occurring within the department are much more serious and severe than they've ever been. We've removed all of our short-term sanctions. We created new definitions as far as what is eligible for return. We do think there is an issue with how the process has been set up with the Rule 74 in the court. And that has been brought up through joint justice, and we would, hopefully there will be some changes to that in the upcoming sessions. We have brought forth some of our concerns with how the rule is brought up and how that process occurs. So this is, thank you.
Thanks, Dale. And one more slide, please, Madeline. So moving forward in terms of this, again, I think some of these speak to some of the different issues that have just been mentioned. One is that Vermont state and agency leadership do need to carefully monitor the returns to incarceration, particularly for people on furlough, in order to understand the impact of the policy and statutory reforms. It is early days, if you will. In addition to changes to community supervision sanction policies, DOC should also complete revisions to their incentive policies that they've begun during Justice Reinvestment 2 implementation. Incentive sanction and revocation data should be collected and monitored for quality assurance and available to inform training needs and ongoing agency decision-making. And state and agency leadership should collaboratively address implementation challenges related to the furlough revocation review process, including the lack of clarity about when and how that process should be applied. And with that, Madeline, I'll turn it back to you.
Thank you, David. And Chief, how about I suggest maybe we finish Act 148, the review, and then we can maybe take our break at that point, and then
okay,
come back and start talking about working group recommendations.
Yeah, that sounds good, Madeline. Let's go there.
Okay. All right. So the next major reform that was a part of Act 148 were the changes to Vermont's existing earned time statute, really meant to incentivize positive behavior change for folks that are incarcerated as well as on furlough. And so some of the implementation milestones include DOC filing both emergency and permanent rules, and then creating an automated system to be able to track earned time. You all also remember that there was additional legislation last session that created additional victim notification requirements, as well as some offense carve-outs for the existing incarcerated population. And that was Act 12, which passed in 2021. And so we do have some initial data on the implementation of earned time from July through October 2021. So again, really short period of time, but some initial good news for you all. So looking at this time frame, July through October 2021, and we found that about 63% of the sentenced incarcerated population and furlough population received earned time each month. So that's an average each month of 63% of the population that's eligible. And then statutorily eligible. And then, but 79% of actually the total population received earned time at least 1 month during that 4-month period. And so when we compare these numbers to the phase 1 pre-Act 148 projections, this is only just slightly less than what we thought that it might be, which indicates that this, even with those offense carve-outs, that this policy is really achieving the impacts that we anticipated would be expected when it was adopted as part of Act 148. So this is some really good news for you all around the implementation of earned time. And so beyond the changes to presumptive parole, community supervision, and then earned time, there were a couple of other pieces of Act 148 that required additional study and additional exploration in several areas. And so one of those areas was the gaps in the racial disparity data and sentencing outcomes. And so to walk you through just a little bit, I think it's good to remember kind of as you all move into the discussions around the Office of Racial Justice Statistics, as well as some of the recommendations that came out of the racial equity and sentencing racial equity and sentencing analysis, just kind of think back that it's been, kind of a very step-by-step process for you all to get to this point. You have the opportunity to really start to realize the impacts of the work that you've done. So Act 148 tasked RDAP and several other stakeholders with developing a report that looked at gaps in race data that can be used to identify racial disparities, and then also challenges to that data collection. So they made that report back in December of 2020. And then kind of out of that, the legislature directed RDAP to continue to examine racial disparity data collection and really start to build out a structure and some kind of guiding mission for what is now being called the Office of Racial Justice Statistics. And RDAP delivered that report in November of this year, so November of 2021. And so during this time, again, per Act 148, the Sentencing Commission reviewed RDAP's December report and also received some additional sentencing data from the Crime Research Group. And we were also able to do some additional analysis around racial disparities at sentencing. So a lot of really significant amount of work. I'm sure Dr. Nazarian Longo has spent many hours along with the rest of many of you that are on RDAP to be able to get folks to where you are now. And so we do really recommend you all kind of continuing to push past the finish line on both of these efforts. One is that improving race and ethnicity related data collection and analysis capacity, and you have a significant opportunity to do this through the Office of Racial Justice Statistics, and then also to advance those recommendations as you decided to do in November for improving racial disparities at sentencing. And as we talked about in November, this is really kind of the most significant focus and work that we've seen the state do using the justice reinvestment process, focused on racial disparities, and we really applaud you for that. And so a second area for additional analysis was around behavioral health, and particularly really how folks that have complex needs, they have substance use needs, mental health needs, that are involved in the justice system are identified and served. So again, there was additional work done past the original phase 1 policy development process to dig a little bit more into these challenges. And if you remember, AHS, along with my colleague, David Zamora, and other folks at the Justice Center were able to do some additional work to identify challenges for supporting people in the justice system with complex needs. And again, really, this identified really a need to focus on information sharing and care coordination. And so at your November 2021 meeting, you received a presentation on challenges to information sharing and care coordination that eventually led to your recommendations, which we'll talk about when we get back from the break in 2021 for both legislative and administrative recommendations to really improve how folks that have complex needs in the justice system are identified and connected to the appropriate services. And so that brings us actually up to your 2021 recommendations. And it sounds like we can take about a 15-minute break here, Chief, if that still works for you.
Okay, Madeline. Thank you. Let's, yeah, so let's come back at 11 o'clock. How's that? All right, everybody. We'll break. We'll come back at 11. Thanks very much. Hey, Madeline.
Hey, you're ready to get started again?
Well, yeah, but what do you see the schedule from here on out? We're going to finish an hour early?
I think it's possible. So we are our plan, we want to briefly go through the 2021 recommendations with you all, and then we anticipate there will be more discussion around the 2022 recommendations, because that's where we want to make sure that that language appropriately reflects the work group discussions, particularly those from October around parole for older adults. And then we have a very quick wrap up, and then we just like to make sure that everyone is on the same page and okay with moving forward, the plan for moving forward with the report. I do anticipate, unless there's a lot of discussion, that could mean that we end earlier than anticipated.
Yeah, I'm not trying to push you either. I just trying to get a handle on what you think. Well, let's there's no way to judge if everybody's back, but we said 11 o'clock. Let's we're 2 or 3 minutes after that, so let's get going, I guess. All right.
Sounds good. Thank you.
Okay. Thank you.
And I'm going to actually turn it back over to David.
All right.
Hi again, folks. Welcome back. And so we want to talk about this particular working group recommendation, there were proposed strategies to improve information sharing and care coordination for folks that are on supervision who have complex needs. Because one of the things that is true in Vermont, because of the great work that you've done to date, is that the folks that you have are indeed people with complex needs, a large number of them. And so the problem with having folks with complex needs is that it requires complex responses in terms of being effective with them. So working group mental health and substance use recommendations included requiring DOC to develop a brief report, including mental health and substance use screening information for judges before sentencing, to inform condition setting for all felony probation cases, because we found that there were a lot of times that conditions were being given without adequate information to make some of those decisions. Recommended AHS convene a cross-department working group to develop and implement changes to policy and procedure that help address barriers to information sharing and care coordination for supporting people in the criminal justice system who have mental health and substance use needs. One of the nice things and unusual things in Vermont is that DOC is part of the Agency of Human Services, as opposed to a completely separate agency out by itself. But to date, that has not always fully been taken advantage of. DOC works hard to have other departments work with them, but there does still tend to be some degree of siloing that AHS is very much working on making different. Additionally, there was the recommendation that DOC explore hiring licensed clinicians to be placed in local supervision offices to administer mental health and substance use screenings and assessments, as well as liaise with the community-based treatment providers. We were looking at how to better integrate what was happening in terms of community treatment and supervision, and to bring the community-based treatment providers up to a uniform level of knowledge and information about working with folks in the criminal justice system. And we recommended that DOC use a validated mental health screening tool for people sentenced directly to misdemeanor probation. Next slide, please. Now, most of the working group's 2021 recommendations that were related to mental health and substance use are still in progress, which makes sense, again, given the complexity of the issues. Act 14 creates 1 to 2 sites in terms of pre-sentencing report pilot, creates a 1 to 2 site pre-sentencing report pilot project. One of the ideas was, let's figure out how to roll this out rather than do this everywhere. How do we do this sort of one step at a time and then build on that as we figure out how to scale it across the state? That is happening. DOC developing a supervision model focused on criminogenic intervention strategies in which clinicians will support supervision staff in working with people who have complex needs, and that's going to be piloted in Burlington. That's in progress. DOC expanding its mental health screening to the misdemeanor probation population. That's been postponed until after Act 14 implementation. Again, how do you build on each thing in a logical fashion? And AHS convening a cross-agency working group, which they have done, and they've had a number of meetings. They've currently paused it to allow DOC to focus on the Burlington pilot project, and then we'll go back to that once there's more information from that pilot project. Next slide, please. As you've all heard me say ad nauseum over the last couple of years, without substantial and sustained collaboration between the AHS departments in support of the shared clients, Vermont will continue to struggle to support those folks who are on supervision who have complex needs. The mass majority of these agencies that you see are within AHS. They are sharing clients, but have historically, though there have been times, there have been attempts where there has been more integration. Overwhelmingly, there's been a lot of siloing, and the department is engaged in breaking down those silos. There will be training coming up in the next month, actually next month, literally next month, starting next month, really working in terms of developing collaborative relationships and figuring out how the different agencies in AHS, helping the agencies in AHS figure out how to better work together and integrate their services for people on supervision. Next slide, please. Now, there are several ways that Vermont can continue to improve how people in the justice system with complex needs are identified and served. And so moving forward, certainly recommending that to ensure that the program and policy changes within DOC, the Parole Board, and AHS are not developed or implemented in silos. Efforts should be closely coordinated with other relevant stakeholders and connect to broader system reform goals. It doesn't matter how good each agency's changes are if they're not made in conjunction with the other agencies, given the complexity of the people under supervision. Moving forward, need to commit to intentional, sustained cross-department coordination within AHS to improve information sharing and care coordination in support of the shared clients with the complex needs. And when developing new initiatives that serve people with complex needs, there need to be clear program level outcome measures that are identified that again connect to broader system reform goals, and to continue to focus on creating a shared cross-system understanding of mental health, substance use, and criminogenic need among supervision staff, community providers, and parole board members. People should be working from the same playbook, if you will, and have the same baseline of knowledge in terms of these complex folks that they're working with. And it's not that everybody has all the depth of knowledge of every piece, but that there is a baseline level that is needed to understand the mental health issues, the substance use issues, and the criminogenic need issues, that everybody that touches the client has an understanding of what that is and why it is that the different systems need to be responding to those individuals in order to improve the potential for success. And with that, Madeline, I'll turn it back to you once again.
Thank you, David. And so the other 2021 recommendation from the working group was focused on changes to the probation midpoint review process. So this actually started out as a conversation around probation earned credit, and you all decided instead of pursuing a probation earned credit policy to instead use a mechanism that Vermont already had in place around midpoint review and making some adjustments to make that a little bit more presumptive and encourage its use. And so in 2021, the legislature passed Act 24, which adopted modifications to the midpoint review process, and then those discharge referrals started shortly after. There have been some implementation challenges that we're aware of related to this particular recommendation. One is related to the criteria for which DOC goes through when they are determining whether or not a case is eligible for discharge under the midpoint review process, and that's that the new criteria did require DOC to make recommendations for discharge for people with a pending new offense, which became challenging then when they went to the courts for consideration. And then also there was a decision in a court decision in September of 2021 that limited the scope of the changes in Act 24 and basically said that they only applied to people that were sentenced to probation after passage. And the impact of this was that it then stops those discharge recommendations under the new policy. So it said that basically the new midpoint review process only applied to folks that were sentenced after the changes were made. And so not to the currently supervised population when the legislation was passed. And so to address some of these implementation challenges, we do recommend moving forward that there is some legislative fixes that, one, prohibit someone from discharge consideration if they have a new pending charge, but that also expands that eligibility for people to be considered under the midpoint review process for discharge as described in Act 24 to the currently supervised population. It's our understanding that these conversations are in place, and we wanted to just emphasize here the importance of that, particularly that expansion to the currently supervised population, and you all kind of seeing any intended impacts of the legislation. And if you reflect back to what we talked about with those community supervision completion and placement rates, this is something that can really help you make sure that you're focusing your supervision resources on the people that need it most, and being able to discharge folks that have been successful on supervision and are really no longer require a level of supervision. And so that wraps up your 2021 recommendations, and we're ready to go into the 2022 recommendations. And there were originally kind of two areas, and you all added on an additional area. You were tasked with studying a parole for older adults policy in Vermont, with examining and making recommendations around options for potential reinvestment funding. And then in November, you all decided to adopt the racial equity and sentencing recommendations and we'll go over those again today as well. So I really, encourage you all as we're going through this section to take a look at the language very closely. If you remember, when we went through a similar process a year ago when we were preparing for your last report to the legislature. Our final presentation before that report included the language that became your report, and we're doing something very similar here. And so we do hope that you'll take a very close look at these text-heavy slides that I'm about to show you, and please let us know if it doesn't reflect kind of what you felt the working group's decisions were, and we can make those changes before we can note those changes now and make those before we are done with our technical assistance. And so the first area of study was the adoption of a parole for older adults policy. And what you see here is a summary of what we heard at your October meeting when we discussed the various recommendations that you could consider related to the adoption of a parole for older adults policy. And so what we heard is that the working group did not come to a consensus on a recommendation for legislative action or inaction regarding the adoption of a parole policy for older adults in Vermont. Working group members did express several concerns, and you'll see 3 of those listed here. One was significant policy underutilization due to a lack of appropriate housing or care available in the facility, so that there just aren't necessarily, even if you have a policy on the books, there may not be the resources in place for someone to release to. An unclear need for an additional release mechanism given the existence of medical parole and furlough, 2 policies that you already have in the state to be able to release folks that meet the criteria for medical release. And then finally, there was concern expressed about the appropriateness of release for people serving sentences for serious offenses. If you'll kind of remember and reflect back to some of the data that we showed you, folks that would qualify under a parole for older adults policy similar to what the legislature has considered in the past tend to be tend to be people that are serving time for more serious offenses, including sexual assault and murder. And so the working group did decide, however, to report the results of your study of a parole for adults policy to the legislature, along with recommendations to explore other options for addressing the needs of the aging incarcerated population in Vermont. So I'm going to pause just a minute there for you to kind of just take a look at the slide, and then also please welcome any kind of comments, questions, additions, and really just want to get a sense of if this seems like a good summary of what you all talked about in October.
So any questions from anybody about this as a statement of the group's consensus on this particular subject, which is parole policy for older adults? Any questions? Comments? Okay, I guess not.
All right. So moving on to the second recommendation that you all also considered back in October, and this was the recommendation around reinvestment or upfront investments, should funding be available. And so in October, we talked about 4 primary areas where you all, not necessarily funding amounts, but should there be funding available, that these are the places based upon the working groups, ongoing oversight of justice reinvestment too, that you all think that it would be helpful to invest funding and resources. And so the first bullet being domestic violence intervention programming through the Vermont Council on Domestic Violence, data collection and analysis capacity, and this includes any additional changes to DOC's data system beyond what's being paid for through the subaward. There was a heavy emphasis on community-based mental health and substance use services and criminogenic interventions for people with complex needs on community supervision. And this could include some of those pending efforts, including DOC's Burlington pilot that David talked about previously. And then lastly, housing-related needs for people on or transitioning to community supervision. And these are, just for reference, these are kind of word for word pulled from the slide that you all considered in October when we discussed these recommendations. So I'll just pause again to make sure that there's not any questions or comments here. All right.
I see no hands.
And so then finally, the last recommendation for your January report, her set of recommendations, is around the racial equity and sentencing analysis that we reviewed in November with you all. And so we've got here just a summary of some of the primary findings from that report. And so in Vermont, was found kind of initially through some of our phase 1 information that Black people are 6 times more likely to be incarcerated than white people. That was the beginning that initially led us and you all to want to dig a little bit deeper into understanding what's behind, what could be some of the potential drivers for that statistic. And then through the sentencing analysis, we found that disparities are present in the cases that are coming to Vermont courts, so in the who's represented as defendants in those cases, and that annually Black people are over 14 times more likely to be a defendant in a felony drug case. And then once before the court, while Black people were found not to be, that they're not more likely to be convicted for most offenses or sentenced to a longer term of incarceration, they were found to be statistically significant racial disparities in who receives an incarceration sentence. So that in-out incarceration decision, as you remember, was a major finding of the racial equity and sentencing analysis, particularly for felony, property, and drug offenses, that Black people are more likely than white people to receive incarceration. when you control for those key case and defendant characteristics, including in-state criminal history and Vermont residency. And so there were 4 recommendations that you all voted on in November based upon the results of this analysis. See, the first recommendation here is related to the classification structure for drug offenses. And I will mention again, these are kind of word for word pulled from what you saw in November. We haven't made any adjustments to this language. So the first recommendation, again, related to the classification structure for drug offenses and applying a racial equity lens to that classification process by reducing lower to mid-level felony drug possession offenses to misdemeanors, and then looking at that highest threshold to make sure that it better reflects significant amounts of drugs intended for distribution. And then the second recommendation is focused on, again, that in-out decision and the disparity that we found between similarly situated Black and white defendants in Vermont, which is to pursue either non-binding sentencing guidance or presumptive probation for certain offenses to provide support for judicial discretion related to those incarceration decisions. And noting that you all already have non-binding sentencing guidance around felony and misdemeanor felony and misdemeanor probation lengths, and that we found that the result of that is that there are not geographic or racial disparities in those term lengths. And then the third recommendation was around the collection and reporting of race and ethnicity data as part of the Attorney General's pretrial services and court diversion report, so that you all are able to kind of understand whether or not there are disparities in who is accessing and program access and use across the state. And so this can include who is eligible for services, who's accessing services, who's denying services. All of those would be really useful measures as you're thinking about identifying whether or not there are disparities in diversion and pretrial services. And so we know this is something that we've talked to the Attorney General's office about. It's very much kind of front of mind for them, and that they're thinking of ways. They were already ahead of us and thinking of ways to access this information. And then the last recommendation is focused on the role of the state's attorneys play in the sentencing process. And that's to explore the use of internal guidance around charging and plea bargaining decisions. And again, this is not to remove discretion, but this is to provide guidance to support the use of discretion that the state's attorneys have in the charging and plea bargaining and decision-making process. And recognizing that guidance can be tailored to, it can be tailored to specific offenses, and we recommend particularly drug-related cases, given the disparities that were found in the racial equity and sentencing analysis. And it can really help support decisions about when and what to charge, and then provide that framework for guiding discretion during the plea bargaining process. And along with that, along with actually kind of instituting that internal guidance, it's important to monitor the implementation of it. So that requires collecting data, examining it and seeing if the guidance is actually being followed consistently. And then some places that have utilized this to address racial disparities have also instituted an internal review process that happens prior to charging for certain charges where there have been found to be where racial disparities are most pronounced. So a limited charge review process. And then finally, there were a series of data-related recommendations. And we do want to emphasize that a lot of our data recommendations are really, they dovetail very, very nicely and are meant to really support a lot of the work that RDAP has been doing around developing the Office of Racial Justice Statistics. We know that a lot of what you see here are things that that they have been talking about in even greater detail than we dove into. So we do want to recognize that. As we mentioned before, we do really recommend expanding the availability of Hispanic ethnicity data to law enforcement and the courts, especially after seeing kind of what what the data shows when DOC has adopted this best practice. We do, obviously there's a need to invest in staffing and system improvements to increase data collection analysis capacity. This is, as David mentioned, this is not an easy thing to do. I know we say a lot. You hear a lot from us. Oh, you've got to improve data collection and analysis. I do want to recognize it's a lot easier for me to say than it is for you all to do, and it does require an investment of time and resources. that it's important to collect and analyze, sentencing data statewide as well as by judicial district when possible. And then identifying ways that you can publish this racial disparity data to make it public so that you can kind of benchmark and monitor progress, and there's availability for folks to engage with the information. And then also really engaging impacted communities in the collection of both the quantitative data, but also exploring qualitative data. Again, I know it's a conversation you all are having deeply in Vermont. It's really important to provide that context to what you can't necessarily see in the numbers, and be able to understand people's lived experience with the system. And continuing to engage folks as you're thinking about developing and implementing policy changes related to racial disparities. And then lastly, you using this information to be able to inform. We highlight judicial training to support consistency in decision making, but obviously there's a lot of other kind of ways that you can use this information for policy making, as well as just to identify training needs and opportunities to be able to take those next couple steps toward a more equitable system. And so I want to just, actually, I'll pause there just to see if you all have any questions or feedback on the racial equity recommendations. All right. And so just to close this section on kind of the 3 rounds of policy development that you all have done, I think it's just really important to take a step back and realize that you have accomplished a lot in a very tough time. You have persevered through really kind of an unprecedented landscape of challenges related to COVID. And you've identified about 1.6 million in reinvestment funding and upfront investments even during this time, and that's huge. And you have processes in place to continue to reinvest funding and community-based resources. And we want to really applaud you for those efforts and that commitment to the reinvestment piece of justice reinvestment. We recognize too the DOC and Parole Board have made significant policy and practice changes. And they're also in the process of doing a lot of work to coordinate some award-funded trainings to support those policy and practice changes. There's also been some really meaningful steps in increasing, the ability for you all to collect data to really understand how people move in and out of your system. And you are going to be able to have access to this data moving forward, and more than even what we were able to show you today, to be able to monitor those outcomes. And in particularly, what I want to highlight for you is that you will have the information to better understand returns to incarceration, as well as the ongoing implementation of presumptive parole, which is becoming even more important when you expand that to some listed offenses in 2023. So lots of really, really great work that you all have done. And now you're kind of set up to be able to say, okay, well, is this doing what we want it to do? And if it's not, how do we make those adjustments moving forward? And then, as David mentioned, we do just want to flag that we think that, given the complex needs of your supervision population, that it's just going to be really, really important for you all to continue to work toward consistent collaboration among AHS departments and the Parole Board when you're thinking about improving care coordination. And you could even expand this. We highlight AHS, we highlight the Parole Board, but it's kind of, all of your criminal justice system stakeholders. It's going to take all of you really making sure that that these, different system partners are all kind of addressing mental health and substance use issues within their own silos. But how do you really connect those together to as a system, improve care coordination for people that have complex needs? And so before we wrap up, and we can talk about the report and what that's going to look like just a little bit more, I'm actually going to kick it over to Loretta to end us out with some sustainability and next steps.
Thanks, Madeline. So in this section, we are going to consider several ways to support the future of justice reinvestment 2 and fully realize all of its intended outcomes. So first and foremost, of course, we're talking data. We want to encourage an increase in all data collection. So if you consider what you've reviewed during this meeting, and of course, past CSG meetings, you can recognize that all the efforts were made possible by data. and simply the analysis that followed. So we're really, really hopeful that data will be the process that will continue to go forward in Vermont. And we especially want to encourage you to look at data collection related to the application of incentives and sanctions, as well as the collection of race and ethnicity data. We understand that that is very important. Second, we want to also focus around reinvestment. We think that reinvestment is very necessary to realize the recommendations of this working group and essentially all of your justice reinvestment goals. So we want to encourage the continuing to direct out-of-state bed savings and upfront investments to a separate justice reinvestment fund to invest in community-based services, especially as it relates to mental health and substance use treatment. We also recommend expanding the time period of spending those reinvestment funds from 1 year to 2 years before the money is moved into the general fund. If you all remember, this occurred in 2020, where the money that was allocated for justice reinvestment was swept back into the general fund. And we hope by expanding the period to 2 years, it will allow for more flexibility to actually spend those funds and make sure that it's used for justice reinvestment. And of course, the one thing that we always recommend is the continued convening of the Justice Reinvestment 2 working group. As Madeline mentioned, as David has mentioned, as we all have mentioned, we have all accomplished so much, and we know that with your continued efforts, there's so much more that you will do. It's important for stakeholders like you to come together, to have these conversations, to review room for improvements, coordinate implementation, monitor data, and just connect all around, just make sure that things are moving forward within the state. So we're really, really hopeful that all of these efforts will be continued. Next slide, please. Okay, so as we close out Vermont, this is what you can expect from us here on out. So as a reminder, although I don't think anyone needs a reminder, but our technical assistance ends this month. So by December 31st, we are no longer here. But in the future, you do have to send a second report to the legislature, and that is due before January 15th. Also in February, our team will continue to share the racial equity and sentencing report, which expands on the findings that we identified in November. And in early 2020, you will receive your first data monitoring report, which Madeline shared at the top of this presentation, and that will encompass all of the data that Angie receives from DOC and the Parole Board. So basically it is, here we are, we're trying to close this out, but we're really, really excited for what the future holds for Vermont. And we're really grateful for all of your efforts as well. Thanks. Oh, and now I'm going to turn it back to Madeline.
Great, thank you so much, Loretta. And so that's the end of our presentation. If it's all right with you, Chief, I'd like to talk about the report briefly.
Yes, please. Thanks, Madeline.
All right. So as I mentioned, how we approached this last year, as you all might remember, is that we had a presentation a little bit similar to this, but not as much of a recap. But also included your recommendation language. And we were able to kind of go through and make some tweaks to the formatting of that, but not to the language. And then we're going to repackage it basically for you all to submit as your legislative report. We are happy to do that again and take kind of what you just saw, attach onto it the slides that you all reviewed relative to the parole for older adults, because again, part of your recommendation was that you report out to the legislature what you looked at. Add that to as an appendix to this presentation, making very, very clear. We'll go back through, make very clear about anything that comes from us as far as like, this is what we're recommending, and here's what you all are recommending as the working group. We can send that out to you all and give you a couple days to just check it out.
I think that sounds great, Madeline. The work that they've terrific experience working with people that are as committed to making positive change as these folks are, obviously. So
I'll just say that we very much have appreciated the opportunity to work with you all. Been with you for a few years now, and some of us will be with you in other projects over the next couple of years. But it has been one of the in my 11 years here at CSG, it has been one of my favorite places to be working. So I want to thank you all for all the work that you have done and how you've been helpful to us as we've attempted to be helpful to you.
Thank you, David. Thank you. Okay, so we'll call it a day for this meeting. Again,